Hi, this is David Bliven, Bronx and Westchester divorce attorney, with another episode of Lessons from the Divorce Wars. So, this lesson is do not miss your discovery deadlines. So, in New York State, in a contested divorce matter, the court is going to set up a preliminary conference order. That preliminary conference order, you can Google it, find it on the court's website. It's going to set up a bunch of deadlines. It's going to set up generally either 30 or 60-day deadlines to respond to mandatory disclosure. That's your 3 years of tax returns, bank account statements, investment account statements, credit card statements. It's also going to set up similar deadlines for responses to demands for discovery and inspection, interrogatory demands. If you're wondering what those are, Google it. Access the court's website, consult an attorney. Okay, so the problem comes in where people leave everything to the last minute. They're like, that deadline, it's so far in the future, I don't really have to do anything about it right now. I'll leave it until day 59. No, don't do that. Just pretty pleased with a cherry on top. It's going to save you problems. It's going to save your attorney problems. And here's the potential problem that you're going to face. If you leave everything to the last minute and then you can't get stuff in on time. Number one, your attorney can request an extension of the judge on disclosure. The judge may or may not grant it. The judge may say that ship has sailed. Potential consequences. You could face monetary sanctions, perhaps in the form of an award of counsel fees to the other side. You can face preclusion of your ability to contest certain issues. You could also face preclusion of your ability to insist that the other side produce disclosure. So in other words, if you haven't produced disclosure on your end, you can't really go before the judge and say, but the other side hasn't produced anything or much of anything. No, you have to have your house clean before you can complain about somebody else's being dirty. So make sure that gets done. Now, the other thing that comes in is if you leave things until the last minute, then you have what, no offense if my clients are listening to this right now, and this is you, if you get stuff in, on a Friday or over the weekend to your attorney and your court date is coming up early this next week, well, here's the problem. Then it's creating an overtime situation on the attorney's staff that you're going to get billed for. So if you don't want to spend extra money that you otherwise wouldn't have to, make sure you get stuff in plenty of time so that the attorney and their staff can properly organize it and get stuff done on time. Now, the attorneys are now required in New York State to have their clients execute an affidavit, is now called an affirmation, pledging that they've completely responded to the other side's disclosure demand. It's the rule is called 20220C. And you have to, generally speaking, meet with your attorney to go over that demand so that the attorney can then sign off on your response. And say, yes, as an attorney, I have gone over this with my client. I can certify, therefore, that their affirmation is not a frivolous affirmation and that they are actually being truthful in saying that they have produced everything in their possession, control, or custody. So you want to get that done well in advance of the deadline so that you can set up that appointment with the attorney. You can go over everything calm and in a measured way so that things aren't like scattered and, oh my God, you're pulling out your hair and you're stressing out. There's no need for that. Just, when you get the notice that a preliminary conference has been scheduled, your attorney should give you a cover letter saying, these are all the documents that you're going to have to start getting together. That's the mandatory disclosure. So you should already hit the ground running 2 or 3 weeks before your preliminary conference, getting your 3 years of tax returns, bank account statements, credit card statements, et cetera, together anyway. Throw it in a Google Drive, throw it in a OneDrive, do it in a zip file, get it over to your attorney ASAP so that their staff can start working on organizing that disclosure production. If you've done that 2 or 3 weeks before your preliminary conference, man, it's going to be easy going forward to then get the rest of the documentation pursuant to that demand for discovery and inspection. You're not going to stress. You're going to get everything in well in advance of any deadline. So that is a lesson. Hopefully, if you're hearing this, take it to heart. If you have a contested divorce case, really help out your attorney and your staff, because it's otherwise going to cause you undue stress and money and possibly sanctions if you don't get this stuff done. If you're looking for other answers to similar questions, check out my blog. You'll find it at blivenlaw.net/blog. See you next time.